Page 2 looks good. Mr. Stroller, or anybody just pipe up if you see something you don't like. Pa- What?
I have 1 of 9, and all of a sudden it stops numbering itself.
I don't know about all that. Plus, I'm still going off the February 7 version.
All right, hold on, Judge.
Unless
I
they're,
have February 2nd, Judge.
And February 7th was the last version until I just opened it. Now 2/11 becomes the version I'm working on now.
That's about pages.
So it's 40 pages.
That's a 1 of 9.
it's 42 pages.
Hold on.
Well, I've done a little bit of cleaning up in anticipation, so, I can email it to Miriam, she can print it out, Your Honor, if you'd like to just print it out from Mr. Stroller.
Yeah, because I only have on my Dropbox on February 7th.
Okay, let's print out, where's it gonna print to? Miriam? Oh, okay. Yeah, email it to Miriam, we'll print it out. We'll get,
Now, if you want me to print what I've got, and you need critical copies, it would be today's version. If you want me to print what's in the Dropbox,
I don't care. Print the most recent one, I'd suggest.
I'm sure.
While we're waiting for it to print out, have you decided on attempted voluntary manslaughter?
Judge, I was just reviewing that you locked out. The only thing that concerned me, Judge, there was a line that said, this is not, look at the very last sentence, it says, this instruction is set forth in the appendix shall be effective when this opinion becomes final. I don't, and I know it just came out, so I wasn't sure if it's final.
I think we have to look on the Florida Supreme Court.org website.
But then when the footnote said if you go to the website, there may be some discrepancy, that's one of the footnotes at the bottom. Or part of that, footnote number 2, says we recognize that there may be minor discrepancies between instructions that appear on the website and the published versions of the instructions.
Ms. Corey, you want a hard copy of this instruction?
No, sir, thank you.
2.
I've got simpler things we could solve.
No, that's what you're saying.
Okay.
You want me to make a few suggestions and start cleaning those up?
Cleaning what up?
Hold on, Judge, I'm gonna put this one on the main.
That's all right.
Just to see. Oh, no, it's on the 10th.
Miriam, how many orders do I owe you?
Okay,
How many
Judge.
orders do I owe you?
Couple of minor things, the indictment, because of our standard language in our segment, says death or great bodily harm of Jordan Davis. I can either include great bodily harm in everywhere it needs to go in the instructions and the verdict forms, or Mr. Strolla could agree to delete it because we proved death, but I'll leave that up to y'all. And I've gone ahead and added it to the verdict forms, but I can take it back out. I sent it over. I think it has to comport with the indictment when we leave it in, death or great bodily harm, or take out the words or great bodily harm.
I think we'll break our report, because that may be confusing us, we're not contesting that.
Okay, then I'll make a note and I will delete any reference to or great bodily harm from the instructions or the verdict forms. attempted to use is excess. And I would move to strike those from any reference in the, that doesn't have to comport with the indictment because manslaughter is necessarily lesser included. So I'm asking if on every sub-finding for manslaughter and attempted manslaughter, that the state only has to say he carried, displayed, or used a firearm. And delete threatened to use or attempted to use.
Is that okay, Mr. Stroller?
That will only attempt.
It's on the sub-findings for manslaughter and attempted manslaughter. Whichever version.
Is that the one that was in the dark? Highlighted?
Yeah, I highlighted that because we needed to address it.
So we just wanted to say we find that they use a firearm.
And he carried, displayed, or used would be the three choices. Anywhere that needs to be, it would be those three choices.
I thought it was just like a surface.
No.
Okay.
Here's what I'm saying.
Never mind.
When it comes to the reclassification language for manslaughter, there are 5 ways to prove it. That he carried, displayed, used, threatened to use, or attempted to use manslaughter. You can enhance on or reclassify on any of those. I'm suggesting that since we proved he actually did use the firearm, he did carry it, he did display it, he did use it, and it wasn't a mere threat or attempt, that we can delete a threat or an attempt.
I don't think you need to carry it with you. You find it true. You find that they use a firearm. I mean, if they find him guilty, they would have to use his firearm.
So you just wanted to say he used a firearm? That's fine with the state,
All right, hang on, Mr. Stroller, we got a new copy coming for you.
Oh, thank you.
So we'll start from the top.
Thank you.
Page number 1. Any objection?
not from the state.
Mr. Stroller,
No, Your Honor.
page number 2.
Fine.
No objection, Your Honor.
Page number 3.
We agree.
No objection.
All right, page number 4.
We agree.
And just for the record, Judge, I know originally we objected to lesser included. So
You
when I
still-
say I agree, it would still be the objection to the lesser included.
Right.
Mr. Dunn, as well as counsel, submit to the court, based on our prior arguments on the record, it should just be murder in the first degree, what was indicted, and that's it. We do understand that Your Honor already denied it, so we're not disputing that with the court. Just
Okay.
for, I didn't know for the appellate purposes, I have to object every time we go through the charge.
I understand. So you understand, though, it's second and manslaughter are the lessers there.
Yes, Your Honor. Okay, let me see this real quick. Go to page, that's okay. No, where's page one?
Page 5,
Sorry, Judge, I'm still on 4, Judge, I apologize.
okay. By the way, they didn't want to film this?
It's we're live right now.
Oh, okay,
I'm the crew tonight, Judge.
okay.
Well, but that was what you had going on this morning, is exactly what we're doing right now, Judge.
I understand, but apparently, from what I've read very quickly on the filing with the DCA, somebody came to the back door, front door, whatever you want to call it, asked to come in, and they were told they couldn't by a bailiff.
You want to say what's the, or over environment?
There's nobody over there. I told them to come over here or watch it live.
Sure. It's not fed over to 407.
That's right, it's live, streaming live right now, audio and video, just a wide shot of the courtroom and the audience, so they're hearing us and seeing a wide shot, and that's all they want.
Okay. And they could hear and see us this morning, but somebody just wouldn't let them come in the room for some reason.
I knew nothing about that until you just said it, and it was recorded and everything this morning, so.
I don't know.
Yes, sir. The state's fine on page 5.
I'm still looking at 4, Judge. Judge, my only concern with 4 is that justifiable homicide is going to be different from our justifiable use of deadly force.
It's a standard instruction.
No, I know, I'm looking at it now.
What I argued yesterday is that 78202 is covered by this instruction and differs from the one under justifiable use of deadly.
Well, the one on 4 only talks about a dwelling, which wasn't part of this. So the one in my justifiable use of deadly force that we submitted talks about the occupied vehicle with the case law. So that's my concern, Judge.
Well, that's in a different place.
No, I understand that, but again, one says justifiable homicide. Well, understood.
You need to probably have your microphone on.
Correct, Judge. This isn't justifiable, hold on.
No.
This isn't justifiable use of deadly. This isn't justifiable use of deadly force, it's justifiable homicide.
Right.
Which is akin to excusable homicide. It's not covered, but it's separate and apart from justifiable use of deadly force.
I'm just it's just going to be, most of these instructions will be confusing for the jury, considering everything that just came out.
Other than it might be confusing, any objection, Mr. Stroh?
No, you're wrong.
Okay, page 5.
State is fine. Can
No
we turn this
objection,
down?
Judge.
Is this loud or is it?
Yeah, it needs to be turned down.
Where's the transcript?
Are we on page 5 or 6, Your Honor?
I was finished with 5, I was waiting on you.
Oh, no, I'm sorry. I said no objection. I apologize.
Okay, page 6.
State's fine.
No objection, Your Honor.
Page 7.
The only thing I bring up on page 7 to comport with the verdict forms is special findings for this count are death of Jordan Davis, which we've all agreed to now to take out great bodily harm, discharge, actual possession, and on the verdict form it says that he committed murder but did not cause death, discharge, or what. A lot of judges want that in. That's where that language came from. It's a 4th finding. However, that language is not in the jury instruction.
Well, first off, are you okay with the part that's highlighted in gray where it just says caused the death of Jordan Davis and took out the great bodily harm part?
No objection to that, Your Honor.
Okay. So then,
You want me to restate it, Judge?
what do you mean?
We would either need to add one more instruction after the 3rd paragraph to comport with the verdict form or take that 3rd finding out of the verdict form. Because basically if they check, we find the defendant guilty of whatever the crime is, murder, then that, and they don't check a sub-finding, then it would just be murder and 1020 life wouldn't apply. I think some judges added the 4th sub-finding on the verdict form to make sure they understood they had to check one of the above.
You're talking about we find that the defendant did not actually possess or discharge a firearm during the commission of the offense.
Right, you would have to add all so it would have to say, we, the jury, find the defendant did not cause death, discharge, or actually possess a firearm during the commission of the crime.
Well, hang on. I'm looking, have you changed the verdict form? Because in the verdict form that I'm looking at, the first sub-finding is discharge a firearm causing the death or great bodily harm.
Right, no, I haven't changed them yet. I have not taken out great bodily harm yet.
All right, well, first off on that, are you okay with taking great bodily harm out of there?
Or great bodily harm, yes, Your Honor.
Okay.
It's on the verdict form.
All right, so that comports with the jury instruction. Then the second one is discharged a firearm. That comports with number 2. The third one is possessed a firearm.
And
Well-
I'm not sure it's supposed to say and did not discharge it. These came from another circuit judge as a suggestion to clarify it for the jury. I will defer to the court on it.
I think, to me, I've never really had that brought up. I've always put the 4 sub-findings in, and I've never put the 4th sub-finding in the jury instructions.
I know. I just want to make sure they match.
I did the verdict form a little more detailed, so it was clearer to the jury that they had to make all these little findings, but I didn't read it to them. I thought it was self-explanatory.
Well, Judge, I think under 1, if you look at the sub-finding under A, it gives clear direction. If you find the defendant guilty of this offense, you must choose one of the following findings. And my suggestion would be the first is we find the defendant discharged a firearm causing death during the commission of the offense. We find the defendant discharged a firearm during the offense. We find that the defendant actually possessed a firearm during the commission of the offense. And that would be it.
I agree. Even though the jury, well, are you talking about in the instruction or on the verdict form?
On the verdict forms, because then it comports with the jury instructions and it comports with the law. I don't think you need the 4th finding because you've already told them that only if they choose number 1, we the jury find the defendant guilty, then they must choose one of the following findings. Well, and then again, maybe that's why they give them that option, is for them to find him guilty of murder and say to the court that
Yeah.
a finding.
No, I like number 4 in there.
Okay, so then we would have to say, we find that the defendant did not actually discharge a firearm causing death, discharge a firearm, or actually possess a firearm, to keep it all going in the right way.
Do you see what she's saying, Mr. Stroller? And do you want it that way?
In terms of the 3rd paragraph and then the 4th subsection, Judge,
Yes.
I think you have to put that in. If we have number 4, we find that the defendant did not actually possess or discharge a firearm during the commission of the offense.
All right, you want me to reread this, Judge, the 4th finding now, to comport with the first 3?
Yeah. Well, the third one would be if you find that he committed murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm but did not discharge the firearm, you should find him guilty of murder in the first degree with actual possession of a firearm.
But I'm just not sure where that extra language came from. I know it's in the instructions too. See, the sub-findings aren't really spelled out well in the instructions because there's so many options. Let me
Well, what are
go-
you saying? Leave paragraph 3 just the way it is? I'm talking about in the instruction itself, not on the verdict form.
Quite frankly, I thought it was easy, in my mind, it would be easier to agree on the verdict form for you to say how you want it read to the jury, and then I can fix the instructions if you want.
Well, that's what I was just doing.
All right, let me go to the sub-findings, or maybe could Ms. Marie go to the sub-findings?
Okay. Now come back.
Yes, sir.
And that was on page 10 again, Your Honor?
No, it's page, yes, page 10. So now we're on to 11. I thought we were going to try and get negligence, justifiable homicide, and excusable in the middle. Mine's printed out off to the left.
Oh, I'm sorry, I thought you did want them over to the left. I thought you wanted the titles over to the left. You want them back all the way in the middle?
Yeah.
My fault.
The first sets are all in the middle.
They were, but then I thought you said they would, because they don't all match up, they
No, I
look
wanted
better.
the first left letter to line up.
Oh, there we go, okay.
Oh. Ooh. I'll have to figure that
I
out.
want the N and the J and the E to be somewhere in the middle of the page, or, you know, a little
But
left
you
of
want
it.
those three to line up.
Yeah,
Okay, I think I can do that. Hold on. I'll use tabs instead of a justification. Can I come show it to you real quick?
well, you can email, well,
Yeah,
Let's just-
I'm gonna submit these as soon, so I think I got it, what you want, Judge, where manslaughter's here and then negligence falls in the same place, justifiable homicide and excusable. Is that
Right.
what you wanted?
yes.
That's what I've got.
Mr. Stroll, is the instruction itself okay on page 11?
My only concern is looking at the attempted one, Judge.
That's
What
not-
it says,
No.
on number 2, Your Honor, it would say intentionally committed an act or acts that caused the death of Jordan Davis. But on the attempted manslaughter, it looks like they have committed an act which resulted in the death.
I know, but they didn't change that.
No.
Yeah, they haven't touched the manslaughter.
No, I know, that's, again, just because of the way it reads and talks about error, Your Honor.
And of course, Judge, in that paragraph, they say in order to convict of manslaughter by act. I mean, that language is in here.
Where?
Right on page, is that 11? What's the one on the right where the second and third findings are? In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. So those words were already included in the standard manslaughter instruction. On
I'm not
page-
seeing where you are.
Page 12, I'm sorry. Is number 2 at the top?
Oh, yeah,
of
yeah,
page
yeah,
12?
I see it.
Yeah, see that paragraph?
Yes.
All right. And then the only other thing when Mr. Strolla decides on that is we need to decide if we're just going to say he used a firearm, which would simplify everything.
Well, any objection to page 11, Mr. Stroll?
None, Your Honor.
All right, on to page 12. It's that paragraph, if you find that Michael David Dunn committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he carried, displayed, used, threatened to use, or attempted to use. What are you're proposing what? Take that out?
Take out everything but used. That was Mr. Strolla's suggestion to avoid confusion.
So you're saying, you should say carried, displayed, or
No.
used?
No, just say, that's what I thought, and then Mr. Stroll said, I have displayed or carried, just say, during the commission of the crime, he used a firearm. You find him guilty of manslaughter with a firearm. Free classification language, and it's actually very clean. And then the last paragraph would have to say the same thing, but did not use a firearm.
Mr. Stroller?
Yes, Your Honor.
What's your pleasure there?
Well, we agree with threatened to use or attempted to use to come out, Your Honor.
Okay? You want to just leave it carried, displayed, and it would have to be or used?
And that would go. What page do we go back when we first talked about striking that? Do you recall, Ms. Corey?
No, this is it. It only comes up under manslaughter and attempted manslaughter, because it's reclassification language, not 1020 life language. And it doesn't have to track the indictment because lesser includeds aren't in the indictment. So it's strictly your call or the court's call based on the evidence that's been put in.
That's its carry, display, or used. Versus one. Then we just read commission of a crime, he used a firearm. But again, he still doesn't take away the justifiable.
And
Okay,
Judge, I would also make it consistent. Instead of using past tense in that first paragraph, I think we should keep it consistent and say he did carry, display, or use, or just he did use a firearm, and keep it consistent because it's in past tense in the first paragraph and present tense in the...
I'm lost on that one, Judge.
Okay, here's my suggestion. Let me just read the two paragraphs. My suggestion is we say, if you find that Michael David Dunn committed manslaughter and you also find beyond a reasonable doubt that during the commission of the crime, he did use a firearm, you should find him guilty of manslaughter with a firearm. In other words, say did use instead of the past tense of used, so that when you get to did
No,
not,
I'm
it's
not,
consistent.
I'm not doing that.
Oh, okay. You don't want to do that?
No.
Okay. So then all I need to
You
know is...
want to leave carried, displayed, and or used in there, Mr. Stroller?
No, because I think if we went back, Judge, we
Then
talked
how do you
about
want it to read?
just to say that during the commission.
How do you want it to read?
That's, just the use, Judge. The commission of a crime, he used a
During
firearm.
the commission of crime, he used.
Firearm.
Okay? Dropping down to the last paragraph.
Yes, sir.
You want to say did not use? And take out carry and display? So it's consistent?
Yeah, that's where it's tough, Judge.
You know, if you're going to be consistent, but just say did not use a firearm.
Just keep it cleaner. It's here, carry, display, or used. It says he did not. Yeah, but we already know. Well, I can't remember. Just for our use and so, okay. Yeah, Judge, to keep it cleaner
Okay?
and consistent.
Got that, Ms. Corey?
Yes, I did, Judge.
Page 13.
I found another reference to attempted voluntary manslaughter in the second paragraph, so I've just highlighted it for now until we make a decision.
Where?
Attempted murder in the first degree includes lesser crimes. It's just in paragraph form,
Yeah, I see it.
so I've just highlighted it until you tell me what to do.
What are we going to call this thing, Mr. Stroller? We need to know.
Which
We've been
one?
talking about it for days. Attempted voluntary manslaughter or manslaughter by act? Or, excuse me, attempted manslaughter.
Oh, Judge, I apologize. I thought we were on page 13.
We
We
are.
are.
Oh, okay.
That's where the first reference to it at all comes up.
You've already got a reference in a prior instruction where they call it,
Voluntary manslaughter by act,
yes,
or manslaughter by act.
they call it manslaughter by
Right.
act.
Yes, sir. And Judge, for the record, I'm on the FloridaSupremeCourt.org website, and 6.6 still reads attempted voluntary manslaughter, so I can't tell the court any more than what's there.
Maria, anything else? Same?
Yes. They suggest calling it only manslaughter by act, that's just proposed instruction. I think honestly, you could just call it attempted manslaughter, because the definition is in there in terms of the manslaughter during instruction, this is exactly right, how it should read. The attempted manslaughter or manslaughter by act, I guess it's extra verbiage in my opinion, is a by act. So, that's my 2 cents.
Make a call, Mr. Stroller. You know, I looked at that picture there in the back,
It looks like you.
looked almost identical to me.
It does.
Except for the glasses.
It does.
Huh?
I heard that thing. I thought it was you.
You're,
Who did?
One of the people in here goes, "This one Phillips." So that's just you back there? Yeah.
That's uncanny. I
It
mean, I've
is.
been mistaken for him, but anyway.
You're a lot more fun. I'm just kidding.
I looked at that and I thought, golly day, man, I guess this is it for me. Because all these guys up here are either passed away or retired. I thought, man, they really are trying to send me a message.
Oh, Lord, they really are.
Anyway, Mr. Strolla,
Yes, sir, Your Honor.
what do you want to call it?
I think to stick with the original 6.6 attempted voluntary manslaughter.
You got it.
Okay.
So that means we can leave page 13 just like it is.
Yes, sir.
Anything else about 13, Mr. Strolla?
1 second, Your Honor. And there's the justifiable deadly force. Ju-
Can we go back to something here? Hold on.
Look here, it's gonna be on the Supreme Court website.
Justifiable homicide, can we take out any dwelling house?
Sir? That,
The justifiable homicide,
it's the same.
it says, or to commit a felony in any dwelling house.
Okay, hold on, Judge. I mean,
The bottom of 13, Your Honor?
Well, then we gotta go back to other places, because it says it in all of them.
Right.
I mean, I'll leave it in there if you want.
Because it does say, I mean, it's a standard instruction, it does say the attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house.
Yep.
So I don't think it's confusing.
Okay. All right, so we okay on 13?
Judge, and I know it's standard language, but on count 2, 3, and 4, it says Tevin Thompson or another person. Count 3, Leland Brunson or another person. I think it's confusing to put in there or another person, because everyone that's been accused of as an alleged victim is in the indictment.
but that other person could be Jordan Davis, so that's why it's alleged that way in the indictment.
But Jordan,
And oddly enough, count 2, Tevin Thompson or another person, the other person
could only be.
theoretically could be Leland Brunson.
It could be, and
There's
that's,
count 3.
And then count 3 is Leland Brunson, and the other person could be Tommy Storms.
And that's my
It's-
concern.
It's kind of crazy, but
That's why I would ask that it would just say count 2, Tevin Thompson, count 3, Leland Brunson, count 4, Tommy Storms. I don't think other person could be Jordan Davis, because it wouldn't be attempted murder. Jordan Davis is deceased. So another person clearly couldn't be Jordan Davis. So my point is, every single person was listed in the indictment, every single person has their own instruction. I think or another, I would ask that that be stricken, Your Honor.
May I be heard?
Yes.
We had shots fired specifically at different portions of the car, and we're entitled to say that those shots were designed for one person or another, which is why we alleged it that way in the indictment. Also, we never addressed transferred intent, and I'm trying to figure out right now if we need to ask for it, but that his intent applies no matter who was in that car, because he was intending to kill. So he was intending to kill either Jordan Davis. Well, he did kill Jordan Davis, that's why you can't use it, that language there, but with the rest of the shots, he was attempting to kill either one of those young men or another person, and it would applies, like you said, if it's Tevin Thompson, then the other one could be Leland Brunson or Tommy Storns or Jordan Davis, because he was still firing. At the time he fired these shots, he didn't know Jordan Davis was dead. So it's not like he completed the act of murder and then went on to shoot at other people.
I'll leave it the way it is. Other than that, anything?
1 second, Your Honor, I'm just making a note.
Okay, well, where is? Okay. Where's transferred intent? Oh, it might be in here already, transferred intent.
So on counts 1, does it talk about justifiable use of deadly force? Because we've got, in that right under count 2, 3, and 4, it talks about was excusable or resulted from justifiable use of deadly force. And I'm not, if I can just go back 1 minute, Your Honor.
Let me look. I want to just make sure it's in there. Is that standard? I think it's out here. Oh, God.
Judge, I think somewhere in count 1, I think we have to have that paragraph. Did I miss it? You notice how, Judge, on count 2, it talks about introduction to attempted homicide, but then mentions or whether the attempted killing was excusable or resulted from the justifiable use of deadly force.
Right, you talking about,
So they have the language standard in attempted murder for counts 2, 3, and 4, but that paragraph doesn't exist for count 1, and clearly that's a defense we're raising for count 1.
Wait a minute.
You see how that, if on page 13, Your Honor,
No, hold on.
right below count 2, count 3, count 4, where we just talked about Tevin Thompson, Leland Brunson, Tommy Storns,
right,
Transfer intent.
it says you will then consider the circumstances surrounding the attempted killing and decide if it was attempted first-degree murder, attempted second, or attempted voluntary manslaughter, or whether the attempted killing was excusable or resulted from justifiable use of deadly force. That paragraph is nowhere in the instructions for count 1 of the indictment with Jordan Davis.
What? It's in the introduction, isn't it?
yeah.
Did I miss it? That's where I was looking.
It's in, that paragraph comes under introduction to homicide and introduction to attempted homicide.
Look at page 4.
That's, okay, that's where I was just making sure, Judge.
Okay. And while we're up there, if the court will indulge me, we are requesting transferred intent. So it would be the short paragraph from the standard on page 6 at the bottom. Transferred intent is,
Judge, we'd only object to that.
I'm sorry, you what?
Objecting to add transferred intent of page 6. Is that what I just heard? Judge, if I can go back to page 4 for 1 moment.
Back to page 4.
Oh, okay. I see it now, Your Honor. I apologize. I was looking at originally just justifiable homicide, excusable homicide. But right above that says justifiable use of deadly force. Let me just see if that tracks, Your Honor, 1 second. Okay. does track, Your Honor. Let's go to page 6.
Where were you finding this transfer intent?
It's on, it's in the part of the standard jury instructions, Judge. It's the last paragraph, transferred intent giveth applicable, under 7.2, murder in first degree. And
Okay.
so it's basically one sentence we're asking to add.
I know that I'm on a different page. I think I just had.
And then I have to see if it's an attempted.
I have it on there
Oh.
already. I just had it up earlier.
You sure you want that?
Well, here's part of the problem. I checked with code counsel and he said yes, but I'd need a couple of minutes to check with him. You want me to highlight it and come back to you on it?
Yeah, because, I mean, the
I-
testimony is that the shooting was at Jordan Davis.
No, no.
That's who got killed.
Yes,
No,
sir.
no.
There was never any,
No, that's okay.
in my way of looking at it,
Oh, see, I thought it was over
That's why I
there's
didn't put
no
it in.
transfer intent.
That's why I didn't put it in there to begin with, but I've got it highlighted, so I'll get back to it, Judge.
Well, I'll make it easier for you, to the extent you've asked for it.
Yes, sir.
What are you saying about that, Mr. Stroller?
We object, Your Honor.
Then your objection is sustained, it's out.
It's out. Thank you, Judge.
There you go.
Okay.
So we were at page 13.
Yes, Judge.
We're good there. Now
Yes, Your
we're
Honor.
moving on to 14.
Other than my objection of the or the other person.
Right,
Yes, yes, sir.
14.
No objection to 14, Your Honor.
15, any objection other than all the other persons?
Let's see, that says accept that someone prevented them or he failed to do so, which I can understand that. No objection to 15, Judge. And I think it's standard that says except that someone prevented or he failed to do so.
I'm sorry? So 15
At
and
the very
16?
bottom of 15, it says except that someone prevented Michael David Dunn from killing count 2, 3, and 4, he failed to do so.
Yeah,
I think we put it, well, I know it's standard, but once you put the except that someone prevented, I don't want to confuse the jury thinking that has to be proven that someone tried to prevent it, but then it does say, or he failed to do so on the next page.
You want me to pull it up on the first page, you mean?
no, he doesn't like preventive, basically.
Oh,
Because it wasn't part of it, and I understand it's a standard instruction, Judge. It should just read, the act would have resulted in the death of count 2, 3, and 4, or he failed to do so.
No, Judge, we think it needs to be in there
Okay.
because what, yes,
Okay.
sir.
Leave it as it is. Rest of 16, okay?
Oh, let me go to 16. No objection to 16, Judge, other than, again, or another person.
Right.
Judge. Yes.
17 deals with the sub-findings on the verdict form, we'll skip it. 18.
No objection to 18, Judge.
19, we now know we're calling this attempted voluntary manslaughter.
It's already out, yes, sir.
Other than that, any problem?
Only the objection to the lesser included, Judge, as stated before.
Okay. Page 20. Other than the objection to another person.
Yes, sir.
We just need to comport the language or make the language comport with the first manslaughter, and I think we all agreed to just use the word used, correct, under the special findings.
We're,
Not at the special findings.
Oh, I'm sorry.
okay. We're still on
I
20, Judge.
haven't gotten there. I'm talking
Oh,
about
okay.
page 20. One thing at a time.
20. Still on attempted. I'm on 21, I don't know how I missed that.
Any problem with 20 other than another person?
No, Your Honor, no objection to 20 other than that stated.
21.
Again, only of the or another person, Your Honor.
Okay. At the bottom of 21, that starts getting into the sub-findings, so we need to tag that and come back.
Yes, sir.
Same thing with 22. It's got some of those sub-findings in it.
Yes, sir.
You're right, if you find also.
Any problem with the definition of a firearm or to actually possess on 22?
One second. Where did I just see firearm? Where did I just have the definition? No objection to that, Judge.
Okay? That moves us on to attempted voluntary manslaughter.
Yeah, one second. Because, these are just lessers. See, count 2, 3, and 4, lesser included, attempted second. No, because it already talks about it up here, because then this goes into lessers. Because if they find it as justified, they don't even go to the lesser. Judge, I apologize.
Page 23.
Yes.
We've got the title right, attempted voluntary manslaughter, that's what you wanted. The first line reads just like this new instruction. To prove the crime of attempted voluntary manslaughter, the only difference is they called that attempted manslaughter by act. The state must prove the following element beyond a reasonable doubt. Michael David Dunn intentionally committed an act which would have resulted in the death of, and then it's counts 2, 3, or 4, I know your objection to another person, except that someone prevented Michael David Dunn from killing, same thing with 2, 3, and 4, and another person, or he failed to do so. That comports with this 6.6 that's attached to the Williams, well, I don't know if it's attached to the Williams case, but it's this Supreme Court SC 12-462, February 6, 2014 revised opinion.
Judge, and on the actual instruction, it doesn't include or another person, it just includes the name or victim. So again, it would be the same objection, but even looking at the standard instruction, it doesn't include anything about another or another person. It just says resulted in the death of, parenthesis, on bold victim, except that
True.
someone prevented it. So again, or another person would be adding verbiage.
On
to-
this new manslaughter instruction, at least the one that we're looking at that's attached to the Supreme Court thing, it does not have another person in there.
Did I get you? Sorry.
What, I'm sorry, I'm missing something.
We're on page 23.
Yes, sir.
Michael David Dunn intentionally committed an act which would have resulted in the death of, count 2, Tevin Thompson or another person.
Yes, sir.
This instruction we have now does not show or another person. It just says victim.
And that would be the old one and the proposed new one as well, Judge. It just says that word victim, there's no strike, there's no underline. It looks like that would be old and new, so to speak.
I apologize for being lost, but take me back. We're on attempted voluntary manslaughter, the old version.
No, we're on the one that's in our packet that's all grayed out.
Okay?
All I'm saying is Tevin Thompson or another person, Leland Brunson or another person, Tommy Storns or another person.
Yes, sir.
The new instruction does not show or another person. I'm told the old instruction does not show or another person, but I'll look it up.
No, you talking about where we separated out the names per count?
Yep.
Well, that's because that's the language tracking how we alleged first-degree murder, attempted first-degree murder. This is a lesser included, so it wouldn't be in the instruction. It tracks the language we purport to have from the indictment.
This isn't in the indictment. It's a lesser
No,
included.
right, but the or another person is. So for the lesser included, we're saying that he either committed attempted first-degree murder of this person or another person, the lesser included of second-degree murder of this person or another person, and manslaughter of this person or another person. That's where that language comes from. It's not part of the standards. It's from
I
how
know
we...
it's not. And the only reason we had it in the others is because you said it was part of the standards.
The or another person? No, Judge, I said we alleged it in the indictment.
So or another person is not in any of the standard instructions?
No, sir, it's how we alleged who he was shooting at in our indictment. I don't recall ever saying it's part of the standards.
I thought you did. But
No, sir, it's
Okay.
it's how we alleged it in the indictment. Like if we had said John Doe in the indictment, it would say John Doe every place that is. So we alleged in the indictment for the main count that the defendant killed Jordan Davis on count 1, but then on counts 2, 3, and 4, we alleged that he did effect the death of Tevin Thompson, a human being, or another person, and did attempt to unlawfully kill the said Tevin Thompson and then the firearm language comes in. See, that's the name of the victim. That has nothing to do with the standards. That has to do with who we alleged in our indictment, and it tracks from the count from the indictment. Every lesser included reads the victim the same way. It's not part of manslaughter standards. It's what the state
Fine.
alleges.
I understand now
Right.
that you're saying it's what
Yes,
you
sir.
allege. I just
Yes, sir.
think it's very, now that I know that, I think it's confusing. And I don't think you need it. Because you've got to count for Tevin Thompson. If they think he tried to kill Tevin Thompson, they're going to find he tried to kill Tevin Thompson. I mean, quite frankly, if they think he tried to kill one of them, he tried to kill them all. Maybe with the exception of Leland Brunson.
That's part of our problem, Judge, and now that we've got the defendant's testimony that 2 people in the back seat were menacing him,
Well, if that's the case, then you're making my argument. I'm thinking he may have killed the guy in the front seat, passenger side, because of the bullets in the door. He might have gotten the driver because the one that came through the back and whizzed by his head.
well, but it
And he clearly got Jordan Davis, and he might have gotten Leland Brunson.
well, that bullet could just as easily have hit Leland Brunson. If you'll recall the photograph that has the dowel in it, it went right straight in the middle of all
I
of them.
understand that, which brings me back to my point. You've got a count covering his attempt to kill every one of them. So we don't need another person. You've named all the people.
What?
You've named all the people. I took that to mean, quite frankly, that to where somebody could find, well, he was really shooting at her, but he almost hit one of these guys.
Well, but Judge, the problem is here, you've got very specific sets of bullets, and the only thing I would argue is, I wouldn't want them to think that it doesn't apply to Leland or Tommy because Tevin was the one at that front door with that set of shots. In other words, I don't want this jury assuming that this set of shots only belongs to Jordan, this set of shots only belongs to Tommy, so we alleged it that way because any of those shots could have penetrated. I've had a case where the shot went through the door, went through the passenger, and then through the driver. That happened in the Amico murder case we tried. So we allege it this way because we don't have to prove who he had a specific intent to kill.
And so you've had this instruction before and never gotten reversed on it, to your knowledge?
The or another?
Mhm.
No, sir.
Okay.
Did they, but if there wasn't an objection, then the defense would have agreed to a special instruction. We're objecting to it because not only did they argue it with, or present it with evidence, they're gonna make arguments. To or another person is basically then now, they're now trying to get transferred intent without even having the definition in there. They've got count one,
I
Jordan
asked for the
Davis.
She asked for
I asked
transfer
for the
intent. I thought I was
definition.
doing you a favor by saying no.
Right, and I wanted it out, but when they put or another person, they're basically getting it in without the definition of transfer. That's what they're arguing. Well, Judge, if they don't believe he tried to commit murder on Tevin Thompson, you can find him guilty of anybody else that was around there. Every single person that they alleged Mr. Dunn either murdered or attempted to murder, to attempt manslaughter, is listed in a count. Tevin Thompson has his own count. Leland Brunson has his own count. Tommy Storms has his own count. Once you start adding or another person, and it's not a standard instruction, and I thought Ms. Corey said the same thing, you are now asking for a special instruction by the state, and we're objecting to that. That's why we think it is misleading and confusing for a jury, because they have a separate count for every individual named.
Judge, all I can say is it's been in the indictment since December of 2012, that language. Nobody ever moved to strike it from the indictment. When we track our victim, we track it from the indictment. And I'm not seeing that argument at all, but I'd like a chance to do the research on it.
Okay. All right, so other than another person,
Now, on page 23, though, it still is adding or another person, but it's not in the standard instruction, so we agree with that.
none of
Right.
this is in the standards. I
Okay.
now know. So we'll revisit another person on all of these.
Thank you, Judge.
So the rest of 23, though. However, the defendant cannot be found, or excuse me, cannot be guilty of attempted voluntary manslaughter by committing a merely negligent act.
Or if the attempt.
The rest of this is stricken.
Well, that, on the new one, we wanted the old one, so I'm just making sure, so what they had stricken would still be in there.
It is.
Is either. Whoop, where are we? Here we go.
But you have got, now you got a hybrid. Because if you go back up to the top, where it says Michael David Dunn intentionally committed an act,
Whoop.
which would have resulted in the death of,
Oh, they did change it. 'Cause I'm
yeah, they
looking-
took out
Right.
was intended to cause the death of and would have resulted in the death
And
of.
that has to go back in. Intentionally committed an act.
So you want the old instruction.
Yes, Your Honor, which was, so we'd have to add which was intended to cause the death of,
Okay, wait a minute. What,
you have them listed.
Okay.
But didn't they also say in the same case that if you use it and it's not final? And that's where they gave the caveats about that exact issue?
Well, the only caption, they just say that these are proposed, it's a disclaimer. They put that in all their opinions. In fact, when I look back at Montgomery and Williams, they say the same disclaimer on all the standard term instructions. So they're like leaving it to us to figure it out. So that is the language that is the main cause of the problem. That section. Which
Okay.
wasn't-
All right. So leave it as it is, but going forward, I just don't know what to do.
I don't either, Judge, and I just have to say as respectfully as I can, we deserve better guidance than this. We all do. And I don't know what the solution is, but to find out today that they've proposed yet another set of changes that affects the standard language and justifiable use of deadly force makes all of our jobs impossible. It just does. And I don't know what to do about it, to be honest with you.
I don't either. Here it is, 5 minutes to 7 tonight.
Yes, sir.
We're still hacking around about this.
And this was the same case we read and reread the other night multiple times.
I want to make it clear that the way it's written here, you have Michael Dick Dunn potentially commit an act which resulted in the death of. That's fine. That part I should say is fine. There's just no language saying which was intended to cause the death.
But that was the old instruction.
Right. But the crux of the problem in that case was the intent.
Well, Judge, would it solve the problem to use the old instruction but just say Michael David Dunn intentionally committed an act which would have resulted in the death of, and just transfer just that one line? Is that what Maria's saying?
Well, I don't know if she's saying that one line does need to be changed.
Okay.
No, I'm saying that's fine.
No, that line needs to be changed to that.
Well,
It needs to differ from the standard instruction. So what I'm saying is, what you guys are proposing is a hybrid. We got a standard instruction that seemingly that first part that we're talking about now should not be there. We've got a new instruction that Mr. Strolla doesn't want to go completely by. Not only does he not want to call it what the new instruction calls it, he wants some language from the old instruction in there.
You know, Judge, having lived through recent cases where jurors have actually opined that these instructions are so confusing they didn't understand them, I don't have any input. I will type whatever you tell me to type. I'm sorry, but I just don't know.
My feeling is roll the dice and go with the new one. I'll call it what you want to call it, which even still makes it a hybrid.
Yes, sir.
So it would still be called attempted manslaughter by act? No?
You told me you wanted attempted voluntary manslaughter. That's what you said you wanted, but I don't care. I'll call it attempted manslaughter by act.
I think our concern was obviously to stick with the old standard instruction, but now we're saying you can't because they struck the line of it was intended to cause the death.
Right.
But then I don't think it matters what you call it. Whether you call it attempted voluntary manslaughter or attempted manslaughter by act, the title is just a title.
I would think that that wouldn't matter. So I'm okay doing the hybrid to that extent.
Well, and that's what I want Mr. Dunn to understand too, is if we're gonna go with the new language of the proposed instruction where it says appendix 6.6 attempted manslaughter by act, we're gonna go with the new language.
That's your choice. what I was saying is, we can go with the thing, the new language in total, or my suggestion is you go with the new language on the body in the instruction, but I'll call it what you want. I'll call it attempted voluntary manslaughter.
I don't
But as I
think-
said,
Yes.
now we're making it a hybrid.
I would rather, because this was as confusing as it was, I would rather keep it as close to, instead of then calling it attempted voluntary manslaughter, if we're gonna go with the actual language they're proposing, because they have strikes through a ton of other stuff, then I think we either have to do attempted manslaughter by act with all of the proposals,
Okay,
because I don't want to start making it a hybrid in terms of the body,
okay,
and then,
I'm good with that.
because then it becomes a special instruction, and then at that point, then it's an effective assistance, where if I said, all right, this is a special instruction, the hybrid, it was confusing enough, and we've spent days on this already.
So we're going back to this.
Well, no, this one's attempted voluntary manslaughter, it's not the attempted manslaughter by act.
It's in my jury instructions.
Oh, is it? I
I'm
apologize.
holding up the
Go-
one that's attached to the opinion. We're going back to the opinion.
Right.
For the appendix where they actually give you
Right.
the instruction,
So we're
Right.
good, that's what we're gonna use now.
and I believe that's on page 25.
25 and 26 should
Okay.
exactly comport with that, Judge.
Okay.
And obviously on my copy it's in red, but that's why I put it in there. I
All right,
think
so we're taking out 23 and 24.
as soon as you
Now,
tell
we've
me,
gotta go backwards.
and correct everything else.
Yes.
Okay.
So
Judge,
20
I can make a note.
Mr. Dunn, you understand all, I mean, I know that's very, very confusing.
I'm almost there.
He wanted, Mr. Dunn wanted to use the old language because of the way it talks, because it talks about, if you look at paragraph.
It's clearer,
Clearer to you?
more clear.
Yeah.
Because I believe we were referring to the defendant cannot be guilty of attempted voluntary manslaughter if the attempted killing was either excusable or justifiable, as I have previously explained in those terms. And that's because if you look at the other paragraph, it becomes a little bit confusing. And I think that was our issue. If you look to the very last, it says in order to convict.
Well,
It says only an intent to commit an act which would have caused death or was not justifiable or excusable attempted homicide.
but part
So-
of the problem is you're defining negligence in the old instruction when it clearly says he committed an act which would have resulted in the death of. I think that's why they struck the negligence language, because that adds to the confusion. So I don't know.
Well, no, it's underlined, by act by committing a merely negligent act. And I know it strikes, I will now define negligence for you.
Right.
But, again, I just think that last line is confusing, even to argue a jury, which we just talked about, where it says, when they've underlined it, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide. Just the other way they had it, and I know they said that was the issue that was causing problems, but in our opinion, that was actually a lot clearer than what it is now
For a layperson,
Pardon?
for a layman.
for anybody.
I agree with you.
Because I like that it said, or if the attempted killing was either excusable or justifiable. So,
Well, then you're back to a hybrid.
no, and that's what I'm trying to avoid, and that's the problem. We like the old instruction, but you have to cut out was intended to cause the death of,
You just have to change that first part.
and then again, it becomes a special instruction, which I'm trying to avoid at all costs, Judge.
But
Well, listen, I'm getting tired of debating it.
So we'll just.
I've asked you people for days to make a decision.
Well, we did make the decision. The problem is now it's changed because you can't use the old language. So that's what I'm trying to explain to Mr. Dunn.
Okay.
So if we do,
Has this new one been ratified, or is it like?
yes,
done?
it has, that's what they were just explaining. See, that was my concern, Judge. We made a decision, but then once we went through it, you can't use that language. So if we use the old name, you gotta still change it, make it a hybrid. So I think basically, we either call it, but we can call it the attempted voluntary manslaughter, but you're still not gonna get that end was intended to cause the death. Now, for that reason, Judge, where it starts the paragraph, however,
Wait a minute, are we back on page 23
No.
and 24?
yes, Judge, on 23 where it says, however, the
Yes.
defendant cannot be guilty of attempted voluntary manslaughter by committing a merely negligent act, or if the attempted killing was either excusable or justifiable, as I have previously explained those terms. And they had struck out, again, they struck out or if the attempted killing was either excusable or justifiable, and they added it at the bottom.
Well, if I may, the reason I believe they did that is you get full instruction in introduction to homicide as well as introduction to attempted homicide as to the fact that it's not
I know, let's just go with
a
the-
homicide or any
I
lesser
wanna do- I
included
wanna do a
if
hybrid.
it's justifiable or excusable.
What do you want to do, Mr. Stroh?
Judge, we're just gonna go with the new one of the attempted manslaughter by act with the new language. We're gonna be as clean as possible.
Okay,
Okay,
so,
So whatever the Supreme Court struck, we'll strike, whatever they added, we'll add,
okay.
and we will stick with the new 6.6 attempted manslaughter by act.
which would be pages 25 and 26.
Yes, sir.
So we're taking out 23
Yes,
and
sir.
24.
And I'll go back and correct any reference to voluntary. I'll search for the word voluntary and change it to attempted manslaughter by act.
And we still have our objections to the or another person.
Right, and we're going to revisit that tomorrow. The state's going to see if they can find some justification for it.
And then just with regard to the enhancement or the reclassification, I just need to know.
We're
if-
revisiting that.
Yes,
and
sir.
when we get through these instructions, if we ever get through these instructions.
Yes, sir.
So we're moving on to
Page 24 now, well, the new page.
page
24.
27.
Yes.
Oh, hold on 1 second, Judge.
Well. the
I'm
re-
going on my hard copy
Yes, sir.
with what I've got. I've taken 23 and 4 out.
Yes, sir, but on
We're
page.
using page 25 and 26. I
Yes,
know
sir.
that it'll be renumbered. I'm not renumbering it now because we're going to go through and we're going to come back.
Right.
So 25 and 26, Mr. Stroller, you're good other than another person, and we have to come back on the enhancements.
I was just seeing if that first paragraph up top tracked the new language on the bottom of where it starts in order to convict, Your Honor. That's all I was trying to match up.
Okay. Okay. I got it.
We good?
Yes, Your Honor.
Okay. 27.
State's good.
No objection, Judge.
Hallelujah.
We're gonna get. I'm sorry, Your Honor.
I said hallelujah,
Oh,
because now we're to the easier part.
yes, sir, Judge.
28,
No objection.
date of the crime. 29, venue. 30, reasonable doubt, burden of proof.
1, 2, 3, 4, 5, 6, 7, 8.
On to 31, weighing the evidence. We got 1 through 8. Which is really 1 through 10, and we struck 7 and 9. State want either 7 or 9 based on what's gone on since yesterday.
I need the standard, yeah, let me look at the standard. I don't think so, Judge, but let me just double check.
Seven was pressure or threat. 9 was,
10, Your Honor, 10.
10 was general reputation.
Yes, Your
No,
Honor.
no, sir, we
Okay.
don't.
So we're good with 1 through 8?
1, 2, 3, 4, 5, 6.
I mean, they're renumbered to 1 through 8.
Yes, Your Honor.
Okay.
All right? Accomplices, informants.
We did not use one, so unless the defense requests it, we're taking it
No,
out.
Your Honor.
Take that out.
Yes, sir, it's out.
We know the defendant testified, so that goes in.
Yes,
Yes,
Your
sir.
Honor. So,
Page 33 comes out.
yes, Your Honor.
Page 34 is in after the video was shown. Ooh. Yeah. You've also, let me go back to page 32, you've got highlighted, give only if defendant testified, so that's obviously in.
Yes, sir.
34, defendant statements, that's in. 35, rules for deliberation. Good to go there.
Yes, Your Honor.
36, cautionary instruction. 37 is notes. 38 is verdict. 39, single defendant, multiple counts.
Whoop. Did you say 39, Judge, or 30?
39 should be single defendant,
Judge.
multiple counts.
Yes,
And
Judge.
40 should be submitting the case to the jury.
We're gonna get to the justifiable use of deadly force.
Yeah, we haven't gotten there yet.
I was talking that to Mr. Dunn, Judge. These are the standard instructions, and this will get submitted inside of it. Yeah.
Okay.
Yes.
So, which one you want to tackle first? You want to go back to these, to match these up with the jury instruction, or you want to tackle justifiable use?
Judge, and for justifiable use, I did send you that copy. I think we just have to add some other things in there as well as I was going through it.
Yeah, well, let's do this. Let's go back and get these verdict forms right, and, because then that's all we got left, so.
Yes, sir.
We're on to verdict form, first off, let's look at the verdict forms. Verdict form number 1. Any objection to that, Mr. Strolla?
And we already took out or great bodily harm under 1A.
Right, but
I don't see it. I guess you did.
I took it out, and then I changed the fourth one to accurately reflect 1, 2, and 3. In other words, saying we did not find number 1, number 2, or number 3.
Right.
Yeah, I don't know if that printed out on your copy, but,
There should be 4 sub-findings.
yes, sir, you said you wanted 4 sub-findings,
Right.
Judge.
Yes, Your Honor, but I believe we said we were gonna take out just causing death versus or great bodily harm. Or
Yes,
great
sir.
bodily harm was gonna be stricken. On 1A, that first subsetting.
Yeah, I took it out, but is
I don't
it's
have, on
your
my
printed
printed copy, it's on there.
Okay, strike it, I already took it out.
Okay, I did.
And then, Judge, you want fourth finding to read, we find that the defendant did not discharge a firearm causing death, did not discharge a firearm, or did not actually possess a firearm during the commission of the offense. That's the fourth finding you're requesting.
Yeah, we find that the defendant did not actually possess or discharge a firearm during the commission of the offense.
Well, that leaves out the first sub-finding, so.
I'm just reading what I got here.
Yeah, no, I changed it because you said you wanted it to be, it's 1, 2, 3, or it's none of the 3 above. So I made the fourth one to reflect that it's none of the first 3.
No, that's not what I meant.
Okay,
I want a place for them to check a block, any one of the 4.
yes, sir.
So the fourth one would be, they've gone through 1, 2, and 3.
Yes, sir.
They didn't check any of them. Number
Yes, sir.
4, we find that the defendant did not actually possess or discharge a firearm during the commission of the offense.
Oh, I see, but you're saying that covers did not discharge and cause death. See, because that's the first sub-finding. I know, it's confusing.
Yeah, sure it does. The first one is, we find the defendant discharged a firearm causing death during the commission of the offense. Second one, we find the defendant discharged a firearm during the commission of the offense. Third one, we find the defendant actually possessed a firearm and did not discharge it. And then the last one, we find the defendant did not actually possess or discharge a firearm. I mean, the way I've got it here is fine. And actually, these are dated 1/28 at 2:21 p.m.
Judge, I just have February 11th, just the ones that were just printed out, February 11th at 5:27 PM.
Well, I don't know, I didn't get a copy of those.
The verdict forms?
Yep.
Yes, Miriam handed them to you, Judge.
I left them on the bench.
They have a highlight on them.
Huh?
I left them on the bench before you came out. They have a. And they gave you.
I've got that, but it doesn't have the right date at the bottom.
What does yours say, Judge?
1/28 to 2:21 p.m. I don't see another set of jury instructions.
Okay. Well, Judge, I'll just type whatever you tell me to. I can track it.
Maybe Miriam's printing another one.
Okay.
Wait a minute,
I still like to put my difference.
I found them.
Okay.
And are we taking out the or great bodily harm?
Yes, I've already taken out or great bodily harm.
Okay. So, jury instruction, verdict, count one, first page. Is that okay, Mr. Stroller?
I'm not sure if you got the new version where it says for 1A, that first subsection, Your Honor? Does that read, we find the defendant discharge a firearm causing death during the commission of the offense?
Yes?
Okay. I have the old.
No, it does
Oh,
not. It says or great bodily harm.
Right, and I've stricken that from this copy.
Okay.
Okay. The last copy I had didn't have that in there.
I know. It was because I redid it to comport with the indictment, and then he agreed to waive it altogether,
All
so.
right.
But I've got what you want.
Okay, so now 2, 3, and 4 are okay.
I think it was
And the
still-
sub-findings under A.
Right, other than the or great bodily harm is gonna be taken out.
That was sub-finding 1. We already got that covered. So now, sub-finding under,
3,
yeah,
correct. Judge.
that's okay? Well, it's highlighted, did carry, display, or use a firearm. You wanted that in there. Because that's in the other one. Right?
No, because I think we just said just use.
Right.
I think we had done just use, Your Honor, I believe.
We did?
I think
Okay,
that
so
we
change
find
that
that-
to use. We find that the defendant did use. Okay?
All right, so now he's agreeing to just use.
Yes.
So it would read, we find that the defendant did use a firearm during the commission of the offense. We find that the defendant did not use a firearm during the commission of the offense.
Correct. All right, so then we have to go over to the instructions on count 1, which is page 7. And the third full paragraph, if you find the defendant committed murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm, that needs to change. He actually possessed a firearm and did not discharge it. So you're just adding in, and did not discharge it, if you want it to read exactly the way number 3, the subfinding reads. Got it? Hello?
Yes.
You got that, Ms. Corey?
Yes, sir.
Okay. So then we're going to put a little fourth thing in there on page 7, right? That's what you all were talking about. That's why we're coming back to these things. You said you now want something in there that says, if you find that the defendant did not actually possess or discharge a firearm during the commission of the offense.
For counts 2, 3, and 4, you have one less sub-finding because there was no death.
I'm not on counts 2, 3, and 4. I'm on count 1.
I'm sorry then. Where are you talking about then, Judge? I apologize.
Page 7 of the jury instructions.
Oh, you went back to the jury instructions. I apologize. I'll have it comport whatever way you want me to. You tell me what you want in there and I'll put it in there.
That's what I'm trying to do.
Yes, sir.
That's what I'm saying. We're back to page 7. The first finding and the second one, the way it reads in there, I believe we said we're fine. The third one needs to add something in there because there's a little extra language in the third sub-finding in count 1. On the verdict form, it says, we find that the defendant actually possessed a firearm and did not discharge it during the commission of the offense. So I thought what everybody wanted was, where it says he actually possessed a firearm and did not discharge it, you should find him guilty of murder in the first degree with actual possession of a firearm. I've never done it this way.
And I think what I said earlier is some judges do it that way.
I don't.
I know. Then I'd rather do it the cleaner way, to be honest with you. I really would.
Fine. Then we are leaving the jury instructions as they are. We're
Okay.
not fooling with these enhancements.
Okay?
This is just more, the verdict form is a little bit different, I understand that, but it's way more self-explanatory and much easier for a jury to figure out. And if they want to somehow find him guilty of one of these things, but they're smart enough to decide to give him a break and find no min-man on it, they can make that finding there, which is what number 4 is on count 1.
Right. Plus you explain the verdict form to them. So
Yeah.
you get to explain that the way
Exactly.
you choose. So I'm happy with
And that's,
them
yeah,
not
that's,
comporting.
okay, you're good with that? Are
I
you okay with
am.
that, Mr. Stroller?
To leave it the way it is?
Leave the jury instructions the way they are, and yes, the verdict forms are going to be slightly different.
Yes, Your Honor. Yes, Your
Beautiful.
Honor.
You guys, now we're talking. So we're taking off all my yellow stickies. That's the best move we made all night. So the only thing on the jury instructions we got to mess around with is another person.
And then the justifiable use of deadly force.
And that's right. Well, and we got to get all the way through these verdict forms, but that's going to be easy now.
Didn't want to leave that part out, Judge.
I know. Okay, we're good now. All right, so count 1. You're good to go. Except you got to change just to use.
That's right. I
Okay.
did.
All right.
Now, under subfinding 3 of count 1, it reads, we find that the defendant did use a firearm during the commission of the
Yep.
offense. We find that the defendant did not use a firearm during the commission of the
Bingo.
offense.
Is that good for you?
So, I'm sorry, on the verdict form, page 1, subsection 1A3.
Mm-hmm.
Say that again, I apologize.
No,
Yeah.
we're actually, we're finished with page 1. We're
Okay,
good.
that's what I was asking.
Now we're over on page 2,
Okay,
big number 3.
gotcha.
The
That's-
sub-findings did use, not carry, display.
Correct, we find that the defendant did use a firearm, we find that the defendant did not use a firearm.
Perfect. So we're good with count 1.
Yes, sir, I had that written in there, yes, sir.
Beautiful. On to count 2. And thank God it'll be the same for 3, 4, and 5.
Yes, sir.
Looks good to me.
Lesser included of manslaughter, number 3.
Now, let me ask you this, did we decide we're calling it attempted voluntary manslaughter?
No, sir,
No.
attempted
Okay.
manslaughter by act.
So
Why
that
don't you change
changes
this?
back.
We're,
Yep.
yeah, we're gonna go back to what they just proposed, the Supreme
Okay.
Court just proposed.
Okay, so now, under count 2, and the same will apply for 3 and 4, number 3, we, the jury, find the defendant guilty of attempted manslaughter by act.
Correct.
Lesser included offense. Now, all we have to do is clean up carry, use, displayed.
Right. And
So,
that'll
we're going-
just say defendant did use or defendant did not use. And then you got to do the same thing for 3, 4, 3 and 4.
I will correct all of those things for all of those counts.
Look at count 5.
Whoop, 1 second, Your Honor.
That's the easy one. Looking behind me to make sure I'm not screwing this up.
We're gonna get to we're gonna include this, and that will include count 5. You're having a concern about the justifiable use? Count 5? Okay.
Five, it says.
Judge, no objection to the way the verdict is for count 5 is read.
Okay.
I didn't know if you were waiting for that, Judge, I apologize.
Yeah,
All right, so on to, that's it. We're just to justifiable use of deadly force.
How come?
And then tomorrow, we'll figure out this,
I should have put.
another person business.
Yes, sir, I'll find case law. No, attempted felony. What's going on here?
Because there's no lesser. Count 5 is just shooting a occupied vehicle, there's no lesser, that's it. So count 5 is either shot or you're justified.
All right.
You can't put justifiable use.
I got a variety of these justifiable use of deadly force jobs.
Judge, I sent you a 3-page or 2.5-page instruction last evening, and I think I added another case law in
Okay.
the email while we were on break. It's just a blurb about it with the actual site, Your Honor.
Okay? All right, I'm looking at what yours is, I believe. Of course, we need to get it in the form that Ms. Corey's printing all these out in, but. Ms. Corey, have you got a copy of this?
I do.
So, the one I'm looking at, an issue in this case is whether Michael, now do you want to go to Michael Dunn or Michael David Dunn?
Michael Dunn.
Do you
I'm sorry.
Do you want Michael Dunn throughout these jury instructions? Leave out the David?
Yeah, let me ask you.
Yes, fine.
I prefer just to be Michael Dunn, Judge. We haven't called him Michael David Dunn the entire trial. I know it's in the information indictment.
And let me tell you, sometimes when I'm reading these instructions, I'll say, I might, even though it says Michael Dunn, I might shift to Mr. Dunn.
That's,
Or I might say Michael Dunn. You know, I kind of rock back and forth, just, I
as
don't
long
know
as
why,
it's
I
in
just
the,
do it.
sorry, Judge. We would just request it say Michael Dunn throughout the instructions.
All right, Ms. Corey, so,
Let me go in and make that change right now. If you'll give me 1 second, I can do it all at one time.
well, I don't want to do that, because I'm going to leave you people. We're going to leave Ms. Corey and Mr. Strolla. You can go, Mr. Dunn can go where he's got to go for tonight, and we'll leave that to Ms. Corey.
Now you sound like your twin in the portrait behind me.
Well, now that it's 7:30, I didn't get lunch, and I'm still waiting on dinner.
That's right, Judge. I'm just gonna go home and go to bed, Judge. Don't worry.
Yeah, I
Don't
hear
worry.
you.
My head's gonna hit that.
Well,
floor.
that's true. I shouldn't do all that. You guys do have a little bit more to think about tonight than I do.
All right.
So I apologize.
That's okay, Judge. We're
We'll
all
sit here with you, Miss Corey. I'm sorry.
I just did it. I made 30 replacements
All
that
right.
quick.
Did you also replace voluntary manslaughter by act, you
I'm
already
gonna
got
go
that
back
done?
and, we've made detailed notes to go back and check all of this. And I'll have this in the Dropbox by midnight.
You better have it before that.
I'll have it as soon as I can. I'm not leaving here until I get it done.
We may not be
Judge.
starting at 10 o'clock
Yeah, I
tomorrow.
hear you. Okay, so an issue in this case is whether Michael Dunn acted in self-defense. It is a defense to the offense with which Michael Dunn is charged if the death of Jordan Davis resulted from the justifiable use of deadly force. We agreeable on that? Then it
Yes,
says deadly force means force likely to cause death or great bodily harm. That's all standard stuff. So we're good there. Next. The use of deadly force is justifiable only if, take out the, only if Michael Dunn,
You might be looking at an older one, because the one I have is out, and we should have sent you, you should have the newer one last night. I did take that out.
okay, reasonably believes that the force is necessary you want to say believes or believed? Well, the instruction says believes.
Right.
Reasoning believes that the force is necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him, or any attempt to commit aggravated assault, aggravated battery, or murder upon him.
Judge, and the only thing I would add there is, I looked at some of the case law, and I know it's gonna sound funny, because it says any attempt, but there is case law that says attempted murder, so I need to have it read, any attempt to commit aggravated assault, aggravated battery, attempted murder, or murder, and then I have to add the definition of attempted murder. I was looking at a case this morning from an appellate attorney in Tallahassee, and the instruction read in it attempted murder. And I know it sounds funny because it says attempt, but I do need to add attempted murder or
Okay.
murder.
Okay.
hold on.
I told her to wait there, because I gotta figure out, I'm gonna
Okay,
finish these
hold on.
instructions as soon as I walk out.
What is going on?
All right, then number 3 is going to read the same. You're going to add the attempted murder in there.
Judge, and I think I also, and I apologize,
And we just have vehicle, no, nothing else.
right, and I think also on number 1 and 2, it needs to say another's attempt to murder him or another, or, and then number 2 would say upon him or another, or, I believe, because of justifiable use of deadly force, as if he's defending himself or another, and there was testimony by him that he believed Rhonda was in danger, Miss Rower was in danger, and another case that I saw did have that verbiage. And again, I know it sounds duplicative, because it says, number 1 would read, another's attempt to murder him, comma, or another, comma, or any attempt to commit aggravated assault, aggravated battery, attempted murder, or murder upon him, comma, or another, or, and read it that way. And
Okay, well, the instructions themselves don't have this or another person.
I just found that today when I got, an appellate attorney in Tallahassee sent me the case and I was reading it. And there's, again, a plethora of ruling instructions. So I did submit the case law in an email, and then I sent it to you just recently.
Want to forward that to Maria?
Can we just know the name of the case? I have several of them here.
I sent you an email as well. I
Is it ODA?
No,
ODE?
that was the one from last evening.
Is it Barnes?
Hold on one second. I only have 100 emails, so I'm gonna have to go all the way back to.
Hold on, I can find it.
Yeah, I got Oda and Barnes.
I did send those too, but there was an additional one that I believe I sent. 1 second, Your Honor. Oh, come on. No, I'll have to look. I have about 5 emails, and I just looked at it. I have 91 new emails, Judge. Oh. ODA does talk about it, the ODEH, and that doesn't have it. I gotta find it. One second, Your Honor. second,
You
Judge.
can't even make sense of it.
I see an instruction you sent me, but I don't see,
No, the one I had sent you last evening had only the another's attempt to murder him or any attempt to commit ag assault, ag bat. I need to add attempted murder there as well. But it only talks about him, meaning Mr.
no, I'm asking about the case law.
Oh, Judge, I apologize. I had sent you two last night, I believe, one again just while we took a recess, and I'm looking at the other one now.
You sent us Barnes and Oda, O-D-E-H.
There should have been, hold on, let me go,
Yeah, I don't see anything else.
hold on, let me go, because I know I did, let me
Well,
just.
you
look
said
at it.
last night,
No, I sent the two to you last night, I think those were the two,
and you sent something today?
right when we stepped out, so that's what I'm looking for.
Roughly what time?
When we were on our break, I sent it through my phone. One, here we go, at 5:14. Oh, it's the Worley, W-O-R-L-E-Y v. State, 848 Southern 2nd, 491 out of the 5th DCA.
Can
But
you
that's not the,
resend?
it was to, I don't know, do you want me to put your email address?
Yeah, I don't care.
Okay. Hey, Corey@coj.net, and I got confirmation at 5:14 this evening.
Wait, did you send another case?
But I didn't get it.
No,
Well, I
I-
sent it to you as well, Judge, and I sent it to the one I
Ah.
know went through.
I'm not seeing it.
Okay, and I'll just tell you this, Judge, I have taken every case from us and from him and put them all in a OneNote, and I don't have that one, but I just resend it.
It's just,
and I'll-
what it is, the title, the subject says JUDF Case Law Supplement, and it's a part of it, but I did send it to the JL
It,
address.
RL. What's
Oh,
JL?
I had JL Healy.
RL.
All right, then I have two bad email addresses for you.
RL.
That would explain why you don't have
Yeah.
it, Judge.
Probably why I didn't get it.
if you just resend that case, I can take the copy and throw it straight in.
I didn't, it
my-
wasn't a copy, it was a quote from it,
Oh, a quote.
talking about the defense theory, as long as there's any support for it, it's valid for the instructions. And I've got to find, and again, I apologize, when I look through, I now literally have over 100 emails, Judge.
All right, let me go ahead and try to correct, I just,
Oh, goodness gracious.
I am going to save these and send them to you, and you make sure I'm gonna send them to myself, and you pull them up and make sure they're all right. I'm just sick on my stomach.
I think I just sent one to you.
Yeah.
No, that was Worley, I did that one. Did I send you Washington v. State?
Well, let's not worry about that.
Okay. Part of it was though, Judge, under the case law, it says if there's part of the defense theory, my concern is the way the justifiable use of deadly force, it only talks about him, about him, about him. And I think it's clear it could be him or another. And his testimony was, I was in fear for Rhonda as well. And if the jury believes he was,
Okay, well,
So
we'll just look at that case. But go ahead and make your changes, so you've got it like you want.
and I will do that. Do you want me to read it on the record and then it might,
No. I
okay.
want you to just do it and send it to us later.
Okay, I will have that done as soon as I walk.
So now we've gotten through 1, 2, and 3.
Yes, sir, Judge.
Now we're at, you've got a definition of ag assault, ag battery, murder,
Okay.
which is premeditated, and then murder second degree,
The only thing I have to add is the attempted murder. I'll add that definition as well, Judge.
okay?
And Judge, just for whatever it's worth, I don't know why you would have murder in 2 and 3 when it's right there in number 1. I can capitalize it, but you just don't need it. And the case law, at least one of these cases, I think it's Murray or one of them, maybe it's Kagan, I don't know, says the 2 suggested ones for a situation like this are aggravated assault and ag battery.
I kind of agree. I thought that the murder, now, you might put attempted murder in there.
Absolutely, we could do that, Judge. I can have it read ag assault, ag battery, attempted murder, because number 1 does say murder, or, and then it goes down.
Okay.
So I can take murder out of 2 and 3
Okay.
and supplement that with attempted murder and put that definition in there, Judge.
Can you live with that, Ms. Corey?
Yes, sir.
All right.
As long as he's making the changes and then he sends me whatever you approve and I will put it verbatim into those instructions.
Okay. And so then you've got your definitions. Then we're moving on to a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent.
Judge, and what I did on that is I'm going to modify it to Michael Dunn is justified. Again, just from reading some of the case law, there was some reversals and fundamental error where they said that the instructions were confusing and circular, where one case actually quoted, and I think it was the Oda case, they put it in quotes saying, you almost have to put the defendant believed the victim tried to commit these crimes. It was extremely confusing, and it usually says that a person is justified, and that was the standard one. But with the cases that I looked at, it did make it very clear. It almost made it sound like you have to be very specific, saying,
All right,
Mr.
Maria,
Dunn believed that this was going to happen by the victim.
look at that tonight.
So instead of it saying a person is justified, I clarified it to that they know it's Michael Dunn is because he's alleging that Jordan Davis was going to do 1 or number 2 of that subsection, Judge. And I think one of the cases, and if your clerk
I wonder
looks
why,
at it-
well,
and I know it says that, and I agree, but when I was reading some of the case law earlier this
okay,
morning.
I got it.
Okay.
Number 1,
Imminent death or great bodily harm to himself or another, or.
okay.
Then we're at number 2.
Imminent commission of ag assault with a deadly weapon, ag battery with a deadly weapon, attempted murder, or murder against himself or another.
And then I just have to add the definition again of attempted murder, Your Honor.
Okay.
Okay?
And then I think we just go down into in deciding whether.
And then you define them again. And we had a case, didn't we, Maria, that says you got to define them again. Ag assault, ag battery, murder.
Oh, the instruction again is related to the manslaughter. This instruction now.
But you are right, it does say do it both times though.
Right.
Right, for both sections, the 1, 2, and 3, you have to do the definitions for 1 and 2. It does say on the standard or instruction, add definitions again, or add definitions here. But I do agree with Maria, Judge, for the attempted manslaughter, we then have to read it again.
Okay.
Okay.
And then it drops us down to in deciding whether Michael Dunn was justified in the use of deadly force.
Right.
You
Which
must
is-
judge him, that was all standard. And I just added Michael Dunn's name in there, the danger facing Michael Dunn need have been actual. Based upon appearances, Michael Dunn must have actually believed that the danger was real. I think the next paragraph was standard as well, Judge. I just added if Michael Dunn was not engaged in an unlawful activity.
Yep. And then the next one is in an occupied vehicle.
And Judge, we're objecting to that, the presumption of fear. I didn't see that, is that in your instruction, Mr. Stroller, the presumption of fear?
It says a person who unlawfully and by force enters or attempts to enter another's occupied vehicle is presumed to be doing so with the intent to commit an unlawful.
Hold on.
Oh, I'm
Slow
sorry.
down, the court reporter's not getting you.
I'm so sorry. I'm so sorry.
Let me do it.
Yes, sir, Judge.
He is presumed to have had a reasonable fear of imminent death. It says, if the defendant was in an occupied vehicle where he had a right to be, he is presumed to have had a reasonable fear of imminent death or great bodily harm to himself if
Jordan Davis had,
Wait, where are we at, Judge? I apologize.
it's called presumption of fear,
Whoop, let me go to it, because I think,
which is why you should read.
I don't think
yeah,
I
this
had
this part's wrong.
I don't think I had that.
Okay.
If
Hold on.
Jordan Davis had, and this says unlawfully and forcibly entered,
And,
removed, or attempted to remove another person against that person's will from that occupied vehicle.
Correct. And the state objects to that. They have not met that standard. It's called the presumption of fear that applies to a dwelling, residence, or occupied vehicle, and we don't believe that that applies, and if that doesn't apply, neither does the following presumption under 776.013.
I agree. This says, basically, what you'd have to have is Jordan Davis entered the vehicle or attempted to remove someone from the vehicle against their will, which never happened. There's no evidence whatsoever of that. Give if applicable. Over your objection, Mr. Strolla, will just show you want it. I'm not going to give it because there's no evidence of it. And at the state's request, not to give it, correct?
Yes, sir, we don't believe that that's applicable.
Okay, then it's out. Now, what else did you think shouldn't be in there?
Well, I'm just
Are
going
we
to point.
there yet?
Oh, there's a follow-up to that Mr. Strolla had originally requested, but I don't see it in his.
Then let's not talk about it.
I don't want to talk about it.
Well, and I put it, because I have it on the instruction I have too, right after in deciding, we went through that in deciding whether a defendant was justified. It was that next paragraph, if Michael Dunn was not engaged in the unlawful activity, so I'm just making sure I'm on the same page with you.
No,
Yeah.
that paragraph comes
Right.
in, if the
That's
defendant was
in.
not, that comes
I'm
in.
just- no,
I'm
I know,
talking
I'm just
about
trying
after that.
And then it goes to a person who unlawfully or by force enters or attempts to enter another's occupied vehicle. And that's the, right,
Called
okay,
the-
there it is. A person who unlawfully and by force enters or attempts to enter another's occupied vehicle, presumed to be doing so with the intent to commit the felony.
No, it doesn't say
Oh, that's underneath.
attempts, it says unlawfully and forcibly entered, removed, or attempted to remove. The word attempt is not in unlawfully and forcibly entered. I
So I'm
think
looking
that's,
under, sorry.
I think that's where the confusion came in earlier, is Mr. Strolla suggested that Jordan Davis could be attempting to enter his car. That's not what this jury instruction says.
But I believe if you read it, Judge, it says 776013 subsection 4. A person who unlawfully and by force enters or attempts to enter another's occupied vehicle.
Well, hang on, stop. Here's what we've got. A person is justified in using deadly force if, one, imminent death or great bodily harm, no problem. Two, ag assault, ag battery, no problem. Now we're defining those things, no problem. Then we get to, and I'm on page 2, middle of the page, in deciding whether Michael Dunn was justified in the use of deadly force, you must judge him by the circumstances. That's standard. That
Yes,
comes
sir.
in all cases. The next paragraph. If Michael Dunn was not engaged in unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat. Okay?
Standard.
That's in. The next one is the one that's out, which is somebody trying to remove him from a vehicle. That's out. Which then means the following paragraph is also out.
Okay. So that would include a person who unlawfully by force enters or attempts to enter another's occupied vehicle.
Right.
And then it says, as used with regard to self-defense, vehicle means this.
Yes, sir. We're saying that those all only track if you give the first paragraph.
Right. So you don't need as used with regard to self-defense and then talking about vehicle.
Right, and that's out over defense,
Objection.
or state's objection defense request.
Now,
Okay.
then, but you get back to, in considering the issue of self-defense, you may take into account the relative physical abilities. That's it.
standard. And I did put Michael Dunn and Jordan Davis. This has defendant and Jordan Davis. But mine is, it has Michael Dunn and Jordan Davis on mine, Judge. I'm looking at what Ms. Corey put in there and what I put in there, Judge.
Okay, and then the rest of it's good.
Yeah,
Yes,
it's
sir.
just those last three paragraphs.
All right.
So
Judge, I know you're not gonna like this, but I would be remiss if I didn't ask you to go back to 78202, the very first paragraph. And I'm not sure why you would talk about an attempt to commit an applicable felony upon him in his occupied vehicle when you've already told them any attempt to commit an applicable felony upon him, wherever he is in the whole universe.
my recollection is there's case law that says you can give them both.
There's a lot of case law.
Huh? That Odie,
Okay. It just looks like it puts a burden on him to prove he was in an occupied vehicle when you're already telling him any attempt to commit the applicable felony upon him, basically implying anywhere in the universe where he is. I don't get it, but Judge, I'll defer to you. We
they
just
want it,
Yes,
and there's
sir.
case law to support it
Yes,
that
sir.
I read, so I'll give it.
Yes, sir. And then there was one section where you said, don't I have to read the forcible felony again? So you have to read it for number 2 and 3. Then you have to read it again for 776.012, and Judge, you're correct. You have to read it again for that paragraph that starts off, if the defendant was not engaged in an unlawful activity. It says, define applicable forcible felony. It gives you that instruction right underneath that paragraph. So I think what you said that, and then I never heard whether or not you felt like you had to redefine them all 3 times, or you can, the second 2 times, you can say, as I've just defined those for you.
I was gonna do it twice. I didn't think I had to do it the third time.
I just would invite you to look at the instruction underneath that paragraph. If the defendant was not engaged in an unlawful activity, that's that whole thing, that's meet force with force. The very last line says, or great bodily harm to himself or another, or to prevent the commission of a forcible felony.
Yep, it does
So
say define
that-
applicable forcible
That's the
felony.
third place it tells you to do it, and I'm just
Okay,
putting you back on the,
I'll put it in there.
okay.
So we'll add all the definitions again after forcible felony,
Yep,
add all 4. So we have attempted ag assault, ag bat, attempted murder. Well, we actually have more, because I have even second-degree murder. Okay, add all definitions again.
all right, now,
That's gonna be
last
a long
thing.
Instruction.
Where are we putting this in here?
My understanding, and of course I changed my pages, but I'll give you a title, because I've already been trying to redact. My thought would be it goes right after count 5, because I'm assuming they're saying it applies to all 5 counts. So it would go between count 5 of the indictment and date of the crime.
Judge, I think it goes right after the introduction to homicide, and that goes in there, and then it goes to count 1 of the indictment as murder. And then-
Maria, where does this go? Justifiable use of deadly force, where does it go in relation to all the rest of them? Wasn't that what we were talking about a manslaughter thing?
Yeah, it was, I imagine it goes right after each of the charges.
Oh. After each charge. It's an affirmative defense that, as far as I can tell, should be read 1 time, and it applies to all 5 counts.
Well,
Is this the case Judge Mitchell was talking about?
yes, it's after the manslaughter, if he has case law and it was reversible error, when it's the manslaughter, you need to read that instruction again. And I have that case law.
I'm sorry,
Even if it's a lesser included?
what?
And Judge, it was my understanding that it's usually right after, or right before you read the homicide. It's the introduction to homicide, and then justifiable use of deadly force before you start going to count 1, count 2, count 3.
All right, so you would want it,
Right before you read count 1 of the indictment, murder in the
Okay.
first degree. And then if we have to do it again, because my other concern that Mr. Dunn had as well is, he wanted it after, to apply to count 5, because count 5 doesn't mention anything about excusable, justified, anything. It just says shooting into an occupied vehicle. Obviously, I'm going to argue that this covers all the counts in the verdict.
Okay. All right, so you're going to read the definitions of forcible felonies, claiming Jordan Davis was committing forcible felonies on him before we've even read the charges on what we've charged him with? There's a case that says that?
No, here's what it says, this is Washington State, it's the first DCA case, and it's 520, second, 606. It says failure to read justifiable and excusable homicide defense contemporaneously with the instruction on manslaughter.
That's in there. Justifiable and excusable doesn't refer to justifiable use of deadly force under 776. That's in the standards that gets read
Right.
in introduction to homicide and introduction to attempted homicide. And you do have to read those in their entirety.
Was it in there?
No. Okay. That's not.
Well, it's, hold on. Let me find manslaughter.
Well,
Because then you have the lessers of attempted manslaughter.
Yeah, no, it's there. In manslaughter, I think, and I haven't read that case. In manslaughter, Maria, we've got
What page?
negligence, this is page 11 of 40. Negligence, justifiable homicide, excusable homicide. That's in there, which is different than justifiable use of deadly force.
Right, and this case cites to, and this is a case that Judge Mitchell kind of caught us in while we were talking about this. It says the Ortega's court, this is a case that was cited further down, that even though the jury was given an abbreviated instruction on justifiable and excusable homicide at the beginning of the homicide instruction, it was reversible error not to read the justifiable and excusable homicide defense in their entirety in the manslaughter instruction given later. They say this is because manslaughter is residual and confined by what it is not.
Well, but you've already said it. The instruction was given at the beginning of homicide, and then it wasn't given again at the beginning of manslaughter, which it is in ours. We've got it covered.
Okay, it's covered?
I believe so. Give me that, I'll read that tonight.
I agree that justifiable and excusable homicide have to be in the places that were just said. I thought your question, and I apologize, I thought your question was where do we insert the affirmative defense that we've just gone over?
I did, and I was led to believe in the hallway that you had to also add in justifiable use of deadly force around the manslaughter instruction, but I don't believe that's what that case says.
I don't either. And I think
So-
it goes after all 5 counts because it's an affirmative defense
agree.
to all 5 counts.
And that way, it applies to all 5 counts. So it would go in after shooting into an occupied dwelling, vehicle.
Vehicle. Then what I would have to add, well, I guess I would argue it, I just want to make sure the jury's clear that that would be justifiable for all counts. And then it's gonna have to say, Judge, and again, I'll change it, the very first paragraph of my justifiable use of deadly force, I think the way to make it clear, say, an issue in this case is whether Michael Dunn acted in self-defense. It is a defense to the offenses, or maybe put all 5 counts, because it says offense singular, but we've got 5 counts.
Yeah.
So I think I want to make it clear, or I think I need to make it clear that it's.
Well, I'd put in there, it's a defense to each of the 5 counts.
And lesser included.
And all lesser included.
Yeah.
And all lesser included, or lesser included offenses. I'm sorry?
Okay, so let me just clear and not confusing.
Sure. Super easy to do. Super easy to do to make it clear. So Judge, correct me if I'm wrong, it's to read, it is a defense to each of the 5 counts and all lesser included offenses with which Michael Dunn is charged. And then again, but here it says if the death of Jordan Davis resulted, but then I still have to talk about the other alleged victims as well. So I need to put the death of Jordan Davis and an attempted death. It's gonna not make any sense.
Let me look at it.
No, I understand, but then you still need it for all 5 counts because they're charged with the attempted of each individual.
All right, an issue in this case is whether Michael Dunn acted in self-defense. It is a defense to each of the 5 counts
Comma.
in the indictment.
Whoop. Hold on, Judge, because I'm handwriting it. Yes, sir.
And the lesser included offenses
Can I put, and all lesser included offenses?
Well, I was gonna say, and the lesser included offenses associated with each count.
Associated, I'm sorry, and all
And all lesser included offenses
associated
associated with each count.
And then again, another
Or you could say each separate
Comma.
count if you
I'm
want.
sorry?
You could say each separate count.
each. Okay. To each of the 5 counts in the indictment, comma, and all lesser included offenses associated with each separate count, comma, with which Michael Dunn is charged.
Mm-hmm.
And then the problem is it gets to singular, if the death of Jordan Davis resulted, but it needs to really go into the attempted murder of everybody listed. Because I don't want the jury to think this is only a defense to count 1.
Well, why don't we just stop it there?
Stop it where, Judge?
Don't put in there if the death of Jordan Davis
Okay.
resulted. Take that out.
So say with which Michael Dunn is charged, period?
Yeah.
So it'll read, just to verify, Judge, if I may. It is a defense to each of the 5 counts in the indictment, comma, and all lesser included offenses associated with each separate count, comma, with which Michael Dunn is charged, period.
Works for me.
And then it goes in the definition of deadly force, and we've already gone through the rest.
Does that work for you, Miss Corey?
And that covers everything.
Judge, what I'm planning on doing is whatever Mr. Strolla types up, if it comports with what you've ordered, I'm just gonna adapt it to the font and insert it.
So we still
Okay.
have to say,
I am officially declaring whatever.
You're waving
Okay.
the white flag.
I have one more proposal to solve the or another person, and I'd like 30 seconds to consult with Mr. Guy, but I think if we give transferred intent, then we could delete the or another person, and that would cover both bases, and then we could argue it in closing arguments.
Did you hear that, Mr. Strolla?
I apologize, I did not, no, sir.
She was saying if you were to agree with transferred intent, we'd take out this another person on all these things.
I don't agree with both.
All right, then I'll look for case law then, Judge, and I'll get with you in the morning.
We can just make it easy and take it out, Judge.
Not if I don't have
Just a suggestion.
to. Judge, can I have your permission to take a picture of the courtroom with the clock in it showing that nobody was here and nobody's been here?
I guess so.
Thank you.
Can I submit that as my brief to the DCA?
Yeah. Because we've talked a lot on the record, and we've said a lot of important things
Well, I
that the
think
public
we're all-
needs to know.
We're live, yeah, so we're still on.
I know that.
We're all here. All right.
Okay, what else?
What else you got, Judge?
Oh,
How's your iPad?
take about a 15-minute break. We got a couple more hours to go.
Judge, for purposes of any further hearings or appeals, would you be willing to note for the record that what time we started these proceedings and that you invited anyone who wanted to come in and that it's been as empty as the pictures I just took since we started?
Yeah, there hasn't been anybody in here other than bailiffs and the attorneys. I guess we've had a live stream. I'm not sure what time we started. We'd have to check the record, but it was probably about 5:30.
Okay. So we've been
Been
live.
here 2.5 hours.
Okay.
And, you know, to the extent that somebody did not get access this morning at 8 o'clock, I suspect that was just something inadvertent. I didn't know it. If they brought it to my attention, I'd have told them to come on in.
Yes, sir.
But nobody told me.
Your Honor, it was across the hall, too.
I understand that, Mr. Smith, and I appreciate it, but there's been another appeal to the District Court of Appeals saying that people were precluded access from the courtroom this morning, even though it was a live feed, not only on the internet, but across the hall. I don't know what happened.
Oh, they get a copy of it.
Yes,
They're gonna get a copy of all the instructions. When recess, our things, they're gonna have.
yes.
Shut it off.
What time you want to get here in the morning? Make sure we got these firmed up.
5 minutes. 5 minutes to 10.
Not, I would say 9 o'clock, because Judge, that
Okay.
way, I mean, I can be here at 9, and then we can look them over, and then Mr. Stroller can go work on his closing argument,
All right, well, I just want to make sure I got a hard copy that I can get copied for myself, and then my plan is I'm going to have 12 copies, one for each juror.
Okay. Well, my goal is to clean everything up that we can,
Send it tonight.
put it in the Dropbox. I'll email it and put it in the Dropbox, the verdict forms and the jury instructions, and then I've left a clear place, insert justified use of deadly force, and as soon as you've approved whatever he submits to you or sends us tonight, I'll conform the font and put it in there.
Okay.
Judge and Judge. So now I have 2 bad addresses for your email. 'Cause
I've gotten some stuff from you.
And I don't understand why. I had R, even, or JL something, but it's R.
RL.
I don't know how I got that, Judge. And when I go to put it in there, it gives me the pre-programmed ones. I don't know if maybe I just missed it. I'm gonna do a test one right now. Just so I have it. And it's RL, correct?
Yeah.
All right, I got it, it's there. Your fix, sir. All right, Judge, I'm gonna go work on that right now, and then I will email that to you as soon as I get the changes to your instructions.
Okay, great.
Yes, sir.
Thank you, guys.
Thank you, Your Honor.
No, he's good.
Good work.
When are we coming back, Judge?
9.
Okay.
Did you get